On a Monday morning in March, my wife handed me divorce papers. By Wednesday, she had filed a restraining order against me. By Friday, the hospital board had received an anonymous complaint threatening my medical license. 3 moves, 5 days, all perfectly coordinated. That's when I understood. This wasn't a divorce. It was an ambush, and I had exactly 30 days to prove it. My name is Kevin Marsh. I'm 39 years old, and I'm a cardiothoracic surgeon at Northwestern Memorial Hospital in Chicago, Illinois. I have been practicing medicine for 11 years. I have performed over 2,000 procedures. I have never, not once in 11 years, had a formal complaint filed against me, a disciplinary action initiated, or a patient outcome that resulted in legal action. I tell you that not to establish my character through self-promotion, but because those facts become relevant very quickly in what follows. Sandra and I had been married for 8 years. We met during my residency. She was a second-year associate at a mid-sized Chicago law firm, sharp and ambitious in a way I found genuinely attractive, the kind of person who understood what it meant to work hard for something and take it seriously. We dated for 2 years, married in a ceremony her parents organized and largely paid for, something I had accepted graciously at the time and would later understand differently. Her father, Gerald Whitmore, was a senior partner at one of Chicago's more prominent family law firms. 30 years of practice, a reputation for winning difficult cases through the application of overwhelming preparation and, when necessary, overwhelming pressure. He was not a warm man, cordial, professionally charming, but with a quality underneath it that I had always registered without quite naming. The quality of a man who categorizes people primarily by their usefulness. I had been, for 8 years, useful. A surgeon husband for his daughter. Stable income, professional prestige, the kind of son-in-law that photographs well at firm events. When I became inconvenient, I discovered what category I moved into. The marriage had been deteriorating for approximately 2 years before the Monday in March. I am not going to pretend it was entirely Sandra's fault. Marriages don't fail in one direction. My hours were brutal the way surgical schedules are. I was absent in the way that doctors are absent. Physically present sometimes but mentally elsewhere. Running through cases, managing the background hum of institutional responsibility that never fully switches off. Sandra had made legitimate complaints about this and I had heard them imperfectly. But I had not been abusive. I had not been violent. I had not been threatening or controlling or any of the specific things that were about to be alleged against me. That is not my characterization. That is the conclusion a Cook County judge would reach 30 days later, after reviewing evidence that Sandra and Gerald had apparently not anticipated I could produce. The Monday started normally. I was home for once, a rare weekday morning off, the result of a rescheduled procedure. I was in the kitchen making coffee when Sandra came downstairs carrying a manila envelope that she set on the counter in front of me without preamble. "I want a divorce," she said. "Everything is in there." I looked at the envelope, then at her. Her expression was composed in a way that felt prepared, the specific neutrality of someone who has rehearsed this moment. "Sandra, I'd like you to read it today," she said. "My attorney will expect to hear from yours by end of week." She took her coffee and went upstairs. I opened the envelope. The divorce petition was standard in its language: irreconcilable differences, equitable distribution of marital assets, joint custody of our daughter Lily. I read through it carefully, the way I read anything that matters, and felt the particular sadness of a marriage ending made concrete in legal language. Then I called a colleague who had gone through a difficult divorce 2 years prior and asked him for his attorney's name. His attorney was a man named Marcus Webb, former Cook County public prosecutor, 12 years in family law, and a reputation that my colleague described simply as the person you want when the other side has lawyers in the family. I made an appointment for Wednesday morning. I did not know yet how important that timing was. Tuesday evening, Sandra served me with a restraining order. I was at the hospital when the process server found me, in the corridor outside the surgical suite, still in scrubs, coming off a 6-hour procedure. The server handed me the documents with the practiced neutrality of someone who has delivered bad news so many times it has become administrative. I stood in that hospital corridor and read the restraining order. It alleged that I had been verbally abusive and physically intimidating towards Sandra over a period of 18 months. It alleged a specific incident 3 weeks prior in which I had, according to Sandra's sworn statement, cornered her in the kitchen and threatened her. I read that paragraph 3 times. 3 weeks prior, I had been in Minneapolis at a surgical conference. I had the hotel receipts, the conference registration, the flight records, and the testimony of 4 colleagues who had dinner with me the evening of the alleged incident. I was in Minneapolis. Sandra knew I was in Minneapolis. She had texted me that evening asking what time my flight home was. She had filed a sworn statement alleging an incident that she knew had not occurred. I stood in that corridor for a long moment. Then I called Marcus Webb and told him our Wednesday appointment needed to become a Tuesday evening emergency meeting. Marcus Webb was exactly what my colleague had described. A lean, precise man in his late 50s who listened to everything I said without interrupting and asked questions that cut directly to the relevant point without detour. I laid out everything: the divorce petition, the restraining order, the alleged incident, and my documented alibi. He listened. He took notes in a small, precise handwriting. When I finished, he looked at his notes for a moment. "You said her father is Gerald Whitmore," he said. "Yes," I said. He nodded slowly, the nod of a man who has just understood something significant. "I've seen his work before," he said carefully. "He's thorough. The restraining order is step 1. There will be more." "What kind of more?" I said. Before he could answer, my phone buzzed on the table between us. It was the chief of surgery at Northwestern, calling at 9:47 in the evening. I looked at Marcus. He looked at the phone. "Answer it," he said. I answered it. The chief's voice was careful and unhappy in equal measure. The hospital board had received an anonymous complaint that afternoon, alleging professional misconduct in 2 unspecified procedures. Pending review, my surgical privileges were under administrative hold. I would not be operating until further notice. I set the phone down. Marcus looked at me steadily. 3 moves in 5 days, he said. Restraining order affects custody. Medical complaint affects income and professional standing. Combined, they create a picture for the court of an unstable, potentially dangerous man who cannot be trusted with his daughter. He paused. "This was planned, Kevin. Well in advance. How do we fight it?" I said. He picked up his pen. "Carefully," he said. "And we start tonight." Marcus Webb operated the way I imagined good surgeons operated before I became one, with the understanding that panic is a luxury you cannot afford and that the most dangerous moment in any procedure is when you mistake speed for progress. We spent 3 hours in his office that Tuesday night. He asked me to reconstruct everything, not just the last 5 days but the last 2 years. Every argument, every incident Sandra might characterize negatively, every financial decision, every interaction involving Lily, every moment that could be reframed by a skilled attorney into something it wasn't. He listened without judgment and wrote everything down in that small, precise handwriting. At midnight, he set down his pen. "The alibi for the alleged kitchen incident is your strongest immediate asset," he said. "Flight records, hotel receipts, conference registration, witness testimony from colleagues. That's not circumstantial. That's documentary. If Sandra filed a sworn statement alleging an incident she knew didn't occur, that is perjury. We document it thoroughly and we hold it." "Hold it for what?" I said. "For the moment it does the most damage to her credibility," he said. "Not now. The temptation is to lead with your strongest card. That's almost always wrong. You lead with it and they adjust. You hold it and deploy it at the right moment and there's no adjustment possible." I understood the logic. It was the same logic as surgery. You don't make your critical move until the field is properly prepared. "The medical complaint is more complicated," he continued. "Anonymous complaints to hospital boards are investigated regardless of merit. The process has its own timeline and we can't accelerate it. What we can do is get ahead of the narrative." "How?" "Who knows your work best?" he said. "At the hospital. Someone whose opinion carries institutional weight." I thought immediately of one person. Her name was Carolyn Gwynn. She was the chief nursing officer at Northwestern, 15 years at the hospital, 12 of them in surgical services. She had worked alongside me on hundreds of procedures. She was precise, direct, and had a professional reputation that was, if anything, more solid than mine. She was also, I would discover, the person who had witnessed something I hadn't known she'd witnessed. I called her Wednesday morning and asked if we could meet privately. She said yes without hesitation. Something in my voice, I think, told her it was serious. We met in her office at 7 in the morning before rounds began. I told her everything. The divorce, the restraining order, the medical complaint. She listened with the focused attention of someone who processes information quickly and accurately. When I finished, she was quiet for a moment. Then she said, "Kevin, I need to tell you something. About 3 weeks ago." I looked at her. "I was leaving the parking garage late, around 8:30 in the evening," she said carefully. "Your wife was in the garage. She was on the phone. I wasn't trying to listen. I was walking past her toward my car. But she was speaking loudly enough that I heard part of the conversation." She paused. She said, and I'm giving you her exact words because I remember them clearly, she said, "The conference alibi is a problem. We need the incident date to be flexible." And then she said, "Dad, I know. Just adjust the filing." The garage was silent between us for a moment. "You heard that," I said. "Clearly," Carol said. "I didn't know what it meant at the time. I thought it was a work call. Now," she looked at me steadily, "now I understand exactly what it meant. Would you be willing to provide a statement?" I said. "I've already written one," she said. She opened her desk drawer and slid a single typed page across to me. "I wrote it this morning before you called. I had a feeling you were going to need it." Marcus read Carol's statement twice. When he looked up, his expression was the closest thing to satisfied I had seen from him. "This is significant," he said. "An independent witness with no stake in the outcome, impeccable professional credibility, providing contemporaneous evidence that the filing date was deliberately manipulated." He set the statement down carefully. "Gerald Whitmore is good, but he made an assumption that there were no witnesses to the planning. He assumed Sandra was alone in that garage," I said. "People planning something they know is wrong tend to underestimate how visible they are," Marcus said. "It's a consistent pattern." He added Carol's statement to the growing file on his desk, a file that had expanded considerably in 48 hours. The Minneapolis documentation was complete. Hotel records, flight manifests, conference attendance logs, and written statements from 3 colleagues confirming my presence at dinner on the evening of the alleged incident. Sandra had alleged the incident occurred at approximately 7 in the evening. I had photographic evidence, time-stamped, geotagged, of myself at a restaurant in downtown Minneapolis at 7:14 that same evening. "How are you holding up?" Marcus asked, not as a pleasantry, as a genuine operational question. He needed to know if I was functional. "I'm okay," I said. "I want to see my daughter." Lily was 6 years old. She was staying with Sandra at the family home. I had moved into a hotel the evening the restraining order was served, because Marcus had advised me clearly that remaining in the house created complications we didn't need. I had not seen her in 5 days. 5 days is not long in the abstract. It is very long when the person is 6 years old and doesn't understand why her father isn't coming home. "We'll address visitation at the preliminary hearing," Marcus said. "That's in 11 days. We go in with the alibi documentation and Carol's statement, and we request emergency modification of the restraining order to allow supervised visitation pending the full hearing." "Will it work?" I said. "Judges in Cook County Family Court see a lot of restraining orders," he said. "They are not naive about how they can be used. When we walk in with documentary evidence that the alleged incident couldn't have occurred and a credible witness suggesting the filing was manipulated." He paused. "Yes, I think it works." The 11 days between Marcus's office and the preliminary hearing were the most difficult of my life. I was not operating. The hospital had placed me on administrative leave pending the board's review of the anonymous complaint, a process that my department chief had told me privately he expected to conclude in my favor, but that operated on its own institutional timeline regardless of anyone's expectations. I was not seeing Lily. I was living in a hotel room with a view of Lake Michigan that I was too distracted to appreciate, working through the case files Marcus sent me each evening, reconstructing timelines and reviewing documents and trying to hold my own steadiness together through the discipline of staying useful. I called my mother in Cincinnati on the 4th day. She listened to everything without interrupting, a skill she had always had and that I had never fully appreciated until I needed it. "Are you eating?" she said when I finished. "Yes," I said. "Are you sleeping?" "Enough," I said. "Kevin." Her voice was the voice she had used my entire life when she wanted to be certain I was listening. "You are the most careful, precise person I have ever known. You didn't build your career on luck. Trust the process. Trust your attorney. And trust that the truth is on your side. Because it is." I held on to that. On day 11, I put on my best suit, picked up Marcus Webb, and walked into Cook County Family Court. The preliminary hearing was assigned to Judge Patricia Moore, a woman in her early 60s with 20 years on the Cook County Family Court bench and a reputation, Marcus had told me, for cutting through procedural noise with notable efficiency. "She doesn't like games," Marcus said in the elevator on the way up, "which works entirely in our favor today." Sandra was already seated when we entered the courtroom. Gerald Whitmore was not present. He couldn't appear as counsel given the obvious conflict of interest, but his fingerprints were visible in the attorney he had retained for Sandra, a man named Philip Cross, senior associate at Whitmore's firm, who had the polished confidence of someone who has won enough preliminary hearings to consider them routine. Sandra did not look at me when I sat down. Philip Cross opened with a straightforward presentation of the restraining order, citing Sandra's sworn statement, the pattern of alleged behavior, and the need to maintain the current arrangement pending full hearing. His language was measured and professional. He was good at this. Marcus let him finish completely. Then he stood up and placed a single document on the podium. "Your Honor," he said, "the respondent has been served with a restraining order citing a specific incident alleged to have occurred on the evening of February 14th at the marital residence in Lincoln Park." He paused. Dr. Marsh was not in Lincoln Park on February 14th. He was in Minneapolis, Minnesota, attending the Midwest Cardiothoracic Surgery Conference. He submitted the documentation package, flight records, hotel receipts, conference registration, time-stamped photographs, and 3 witness statements from colleagues. Judge Moore looked through the package with the focused attention of someone who reads quickly and retains accurately. Philip Cross was very still at his table. "Furthermore," Marcus continued, "we are submitting an independent witness statement from Carol Nguyen, Chief Nursing Officer at Northwestern Memorial Hospital, who has provided a sworn account of a conversation she overheard approximately 3 weeks ago, in which the petitioner discussed adjusting the filing date of the alleged incident with a third party." He submitted Carol's statement. Judge Moore read it. She set it down. She looked at Philip Cross over her reading glasses with an expression that was entirely professional and communicated something very specific. "Mr. Cross," she said, "would your client like to respond to the alibi documentation?" Philip Cross leaned toward Sandra and spoke quietly. Sandra's jaw tightened. A brief exchange, low and urgent. Cross straightened. "We would request additional time to review the submitted materials, Your Honor." "I'm sure you would," Judge Moore said. She looked back at the documentation. "The alibi evidence is documentary and time-stamped. The witness statement is sworn and signed. This court finds insufficient evidentiary basis to maintain the restraining order in its current form pending full hearing." She set the papers down. "The order is modified to allow supervised visitation between Dr. Marsh and his daughter, beginning immediately, at a neutral location approved by both parties." She looked at both tables. "I will also note for the record," she said carefully, "that filing a sworn statement containing a material misrepresentation as to the date of an alleged incident is a matter this court takes seriously. Counsel should advise their client accordingly." She moved to the next item. "I saw Lily that afternoon. The visitation was arranged at a family center in Lincoln Park, a neutral space with a designated supervisor present, toys and books on low shelves, windows that let in good afternoon light. Marcus had arranged it within 2 hours of the hearing concluding. Lily was already there when I arrived, sitting at a small table drawing something careful and concentrated, the way she always drew, with her tongue slightly between her teeth the way she had done since she first learned to hold a crayon. She looked up when I walked in. "Daddy," she said, just that, and got up from the table and crossed the room and put her arms around my waist the way 6-year-olds hug. Completely, without reservation, with the full weight of everything they feel. I held my daughter in that room and felt something that had been wound impossibly tight inside me for 11 days release by degrees. "I missed you," she said into my jacket. "I missed you too, baby," I said. "So much." She pulled back and looked up at me with the serious evaluative gaze she had always had. This quality of paying genuine attention that she had carried since infancy and that I found, every time, remarkable. "Are you okay?" she said, 6 years old, asking if I was okay. "I'm getting better," I said honestly. She considered this. Then she took my hand and led me back to the table where she had been drawing. "I'm making a house," she said. "You can help." I sat down beside her and picked up a crayon. "Tell me about the house," I said. The full hearing was scheduled for 19 days later. In those 19 days, Marcus and I built the case with the methodical patience of people who understand that the quality of preparation determines the outcome before the proceeding begins. The medical complaint was resolved on day 14. The hospital board's investigation, which had proceeded on its own timeline throughout, concluded that the anonymous complaint was unsubstantiated. Both procedures cited in the complaint were reviewed by an independent surgical committee and found to be entirely within standard of care. My administrative leave was lifted. My surgical privileges were fully restored. The board's final report noted that the complaint had been filed anonymously and that the timing, coinciding precisely with the initiation of divorce proceedings, had been considered in their assessment. Marcus added the report to our file. The picture building in that file was, by day 19, comprehensive and damning. Not just the alibi, not just Carol's statement. Marcus had, through the discovery process, obtained Sandra's phone records for the 6 months preceding the divorce filing. Records which showed a pattern of communication with Gerald Whitmore's personal cell phone that mapped directly onto the development of the legal strategy against me. 37 calls in the 6 weeks before the Monday in March. Several on the same day as specific filings. "This establishes coordination," Marcus said, laying the phone records on his desk. "Not just between Sandra and her attorney, between Sandra and her father, who is a named partner at the firm representing her, directing strategy while maintaining the fiction that he has no formal involvement." "Is that actionable?" I said. "It's relevant," Marcus said carefully. "Whether it rises to sanctions depends on the judge. But it speaks to the integrity of the entire proceeding, and Judge Moore has already indicated she's paying attention." On the evening before the full hearing, I drove to my father-in-law's office. I want to be precise about this. I did not go to threaten or confront. Marcus knew I was going. He had not advised it, but he had not prohibited it, and I think he understood something I was only beginning to understand myself, that there was a conversation that needed to happen outside the courtroom before we walked into it. Gerald Whitmore's assistant was gone for the evening. He was still in his office, the light was on, visible through the glass, and he opened the door himself when I knocked. He looked at me for a moment without speaking. "Kevin," he said finally. "Gerald," I said. 5 minutes. He stepped back and let me in. His office was exactly what you'd expect. Dark wood, framed degrees, the accumulated visual authority of 30 years of winning. He sat behind his desk. I sat across from it. "I know what you built," I said. "I know you coordinated the restraining order, the medical complaint, the filing date. I know all of it, and so does Marcus Webb, and so, increasingly, does Judge Moore." Gerald said nothing. His expression was the expression of a man who has been in difficult rooms before and knows how to wait. "What I want you to understand," I said, "is that tomorrow I am going to walk into that courtroom and present everything we have. Not to destroy Sandra. She is Lily's mother, and that matters to me regardless of what she has done. But to establish the truth completely and permanently." I leaned forward slightly. "And if you have any remaining influence over how Sandra approaches tomorrow," I said, "I would strongly suggest she come ready to have an honest conversation about Lily's future. Because the alternative is a judge who has already flagged a potential perjury issue deciding custody for 2 people. one of whom has documentary evidence supporting every claim he has made, and one of whom does not. Gerald looked at me for a long moment. For the first time in 8 years of knowing this man, I saw something in his expression that I had never seen before. Uncertainty. I stood up. "Tomorrow," I said, and I walked out. The morning of the full hearing, I was up at 5. Not from anxiety, or not only from anxiety. More from the particular alertness of someone who has spent 30 days preparing for a single moment and finds, when that moment finally arrives, that sleep feels like a waste of the remaining time. I made coffee in the hotel room. I stood at the window and looked at Lake Michigan in the early dark, that vast, flat expanse of water that looks like an inland sea on winter mornings, gray and still and entirely indifferent to what was about to happen in a courtroom 12 blocks away. I thought about Lily. Every decision of the last 30 days had been made with her at the center of it. Not revenge. I want to be honest about that, because the desire for revenge had been present and I had recognized it and set it aside deliberately. Not because I was above it, but because I understood that in a custody proceeding, the parent who is visibly focused on their child's well-being wins more than the parent focused on destroying the other side. Marcus had told me that in our first meeting, and I had believed him. I still believed him. I finished my coffee, put on my suit, and drove to meet Marcus. The courtroom felt different from the preliminary hearing. Fuller, somehow, the weight of what was at stake made the room feel smaller and more serious simultaneously. Sandra was already there with Philip Cross. She looked, if anything, more composed than she had 11 days ago, pulled together in the specific way of someone who has been coached carefully on presentation. Gerald Whitmore was not present. That absence, I noted, was different from the preliminary hearing. Then his absence had been strategic, maintaining the fiction of non-involvement. Now it felt like something else, like a man who had assessed the terrain and made a calculation about where he was most useful. Marcus noted it too. He said nothing, but I saw him register it. Judge Moore entered at 9 sharp. Marcus opened with a methodical and comprehensive presentation of our evidence. He did not lead with the strongest material. He built toward it, establishing first the timeline of the marriage, my professional record, my involvement in Lily's daily life. He submitted school records showing my documented participation, parent-teacher conferences, pickup and drop-off logs, medical appointments. He submitted statements from Lily's pediatrician, her teacher, 2 parents from her school who had known our family for years. He was building a portrait, not of a man defending himself against accusations, but of a father present, consistent, genuinely involved, whose involvement with his daughter was documented across years of ordinary life. Philip Cross objected periodically. Judge Moore sustained some, overruled others. She was listening with the focused attention I had observed at the preliminary hearing, taking in everything, filing it accurately, already thinking ahead. Then Marcus moved to the allegations. He presented the alibi documentation again, not because it was new to the court, but because he wanted it formally entered into the full hearing record with complete supporting materials. Flight records, hotel receipts, conference documentation, time-stamped photographs, colleague statements. He presented Carol Nguyen's statement again. And then, the piece he had saved, the piece Philip Cross did not know was coming. He presented the phone records. 37 calls between Sandra and Gerald Whitmore's personal cell in the 6 weeks before the divorce filing. He walked through the timeline, each call, its duration, its proximity to a specific filing or action. The restraining order, the medical complaint, the adjusted incident date. This communication pattern, Marcus said, turning to face Judge Moore directly, establishes that the legal strategy deployed against Dr. Marsh was coordinated not merely between the petitioner and her attorney of record, but between the petitioner and her father, a senior partner at the representing firm, who has directed this proceeding while maintaining the appearance of non-involvement. He paused. The court is therefore looking not at a legitimate protective action by a spouse in genuine fear, he said, but at a coordinated legal strategy designed to accomplish 3 specific objectives: removal of Dr. Marsh from the marital home, damage to his professional standing, and establishment of a custody narrative. In advance of divorce proceedings, the petitioner had been planning for months. He sat down. The courtroom was very quiet. Philip Cross's response was competent but visibly constrained. The performance of an attorney who has lost control of the narrative, and is working to minimize damage rather than win ground. He challenged the interpretation of the phone records. Marcus had anticipated every challenge and had responses prepared. He questioned Carol's account. Marcus pointed out that Carol had submitted a sworn statement, was present and available to testify, and had absolutely no personal interest in the outcome of the proceedings. At one point, Philip Cross made a line of argument suggesting that the alibi documentation, while extensive, did not preclude a prior incident on a different date that Sandra had misremembered as February 14th. Judge Moore stopped him. "Mr. Cross," she said, "the sworn statement filed by your client specified February 14th, not approximately mid-February, not a date the petitioner was uncertain of. A specific date, sworn under oath." She looked at him steadily. "Are you suggesting the petitioner was mistaken about the date of an incident significant enough to warrant a restraining order?" Philip Cross paused one beat too long. "We would argue. I have what I need," Judge Moore said. She delivered her findings 40 minutes later. "I will not reconstruct the full legal language. Courtroom findings are dense and procedural, and the substance matters more than the form. The substance was this. The restraining order was dismissed in its entirety. The court found insufficient credible evidence to support the allegations and found affirmative evidence suggesting the allegations had been constructed and the filing manipulated. Primary physical custody of Lily was awarded to me, with Sandra receiving generous scheduled visitation, every other weekend, extended summer access, all major holidays alternating. The court noted that Lily's relationship with her mother was important and should be maintained, but that the parent who had demonstrated consistent, documented, good faith involvement in the child's daily life over multiple years was the appropriate primary custodian. The marital assets were to be divided equitably, a process that would take additional proceedings to complete, but that began from a baseline the court characterized as fair to both parties. And then Judge Moore said something that was not part of the standard findings. She noted, for the record, that the court had observed evidence suggesting the petitioner had filed a sworn statement containing a material misrepresentation, and that the coordination of legal strategy through an undisclosed party raised serious ethical questions. She was referring the matter to the Illinois Attorney Registration and Disciplinary Commission for review. Gerald Whitmore's law license. Marcus had not told me that was possible. I don't know if he had anticipated it or if it was entirely the judge's initiative. Either way, I sat at that table and listened to Judge Moore refer Gerald Whitmore's conduct to the Disciplinary Commission and felt something move through me that was not satisfaction exactly. More like the specific relief of watching a structure that has been under extraordinary load finally, completely supported by the ground beneath it. Marcus shook my hand in the hallway with both of his, the same gesture Rebecca had used, I thought, and I understood now that it was the gesture of someone who has invested in an outcome and seen it realized. "Well done," he said. "You did the work," I said. "You gave me the truth to work with," he said. "That's not nothing. That's everything." I picked Lily up from school that afternoon. She came out through the double doors with her backpack slightly too large for her small frame, scanning the pickup line the way children scan for familiar faces, and when she found mine she broke into the particular run of a 6-year-old who is not yet self-conscious about running, arms slightly out, completely committed. I crouched down and she hit me at full speed and I caught her and held her and she smelled like school, crayons and lunch and the specific warmth of a child who has been inside all day. "Are we going home?" she said. "We're going home," I said. She pulled back and looked at me with those serious evaluative eyes. "For real this time?" she said. Something tightened in my throat. "For real this time," I said. She considered this with the gravity of someone confirming an important fact. Then she took my hand and we walked to the car. I returned to the operating room 3 days later. My first procedure back was a mitral valve repair. A 4-hour surgery on a 62-year-old man from Evanston who had been waiting through my administrative leave with the patient anxiety of someone who has been told their heart needs fixing and is ready to have it fixed. I scrubbed in. I felt the familiar settling that happens when I am in that room, the world narrowing to the relevant, the noise falling away, the work becoming everything. Carol Gwynn was in the corridor when I came out. She looked at me with the quiet assessment of someone checking that a colleague is intact. "Good?" she said. "Good," I said. She nodded once and walked on. Sandra and I have not spoken directly since the morning she handed me that envelope in March. Everything since has gone through attorneys, which is appropriate and which I expect will remain the case for some time. Lily transitions between us with the careful logistics of divorced parents doing their best. Pickup times, handoff locations, the shared calendar Marcus helped establish that keeps everything documented and clear. Lily is doing well. She is resilient in the way children are resilient when the adults around them are honest with her about what has happened in age-appropriate terms and consistent in showing up. I show up, every time without exception. Gerald Whitmore's disciplinary review is ongoing. I do not know its outcome yet. I have stopped tracking it because the outcome, whatever it is, belongs to a process I have no control over, and the part of this story that belongs to me is already finished. There is a thing they teach you early in surgical training, a principle that sounds simple and takes years to fully understand. You cannot operate on a patient you are emotionally attached to. Not because the attachment makes you less skilled, but because it makes you less clear. Clarity is what the work requires. Clarity about what you are seeing, what it means, and what needs to be done. The last 30 days taught me that the same principle applies to the rest of life. I had been living inside a marriage the way you live inside a building you designed and trust, assuming the structure is sound because you built it carefully and cannot imagine it failing. I had missed things I should have seen because I was inside them. I see clearly now. My daughter is home. My work is restored. The truth is on the record. Some structures, when they fail, reveal that the foundation was never what you thought it was. You don't rebuild on a compromised foundation. You clear the site, and you start again carefully with better information on ground you have tested yourself. That is what I am doing. One day at a time.